Good afternoon, everyone, and welcome to this webinar on the intersection of intellectual property, traditional knowledge, and cultural heritage. My name is Aldo Fabrizio Modica Bareiro. I'm partnered at Bareiro Modica Abogados in Paraguay, and it's my pleasure to moderate today's discussion organized by the International Association for the Protection of Intellectual Property, AIPPI. Traditional knowledge and traditional cultural expression are an essential part of the identity, history, and creativity of many indigenous people and local communities around the world. This knowledge system has been developed and transmitted across generations, often collectively, and they play a fundamental role in areas such as culture, medicine, agriculture, craftsmanship, and biodiversity conservation. However, protecting this form of knowledge and cultural expression within the framework of modern intellectual property law raises a number of complex legal and policy questions. Traditional IP systems were largely designed to protect individual creators, identifiable authorship, and limited term of protection. In contrast, traditional knowledge and cultural expression are often collective, intergenerational, and deeply embedded in the cultural heritage of communities. This creates an important challenge. Among them are the risks of misappropriations, cultural harm, and economic exploitation, as well as the difficulty of reconciling concepts such as public domain, collective ownership, and cultural rights. At the international level, these issues are currently being discussed in several forums, including negotiations at the World Intellectual Property Organization or the Intergovernmental Committee of the Genetic Resources and Traditional Knowledge and Folklore. At the same time, many countries are developing their own national legal frameworks and policy responses. Today's panel will explore this question from different regional perspectives, including Europe, Mexico, and India. Our speakers will share insights on national legal frameworks, institutional approaches, practical case studies, and the challenge posed by new developments such as digital access and artificial intelligence. Before we begin, let me briefly explain the format of the webinar. Each speaker will first present their perspective on the topic. After the presentation, we will move to a short discussion where I will pose a few questions to the panelists. We will also try to reserve some time for questions from the audience. With that, let us begin our discussion. So, it's now my great pleasure to introduce our first speaker, Vidisha Garg. Vidisha is a partner at Ann & Ann in India and has an extensive experience in intellectual property law, particularly in matters relating to traditional knowledge and cultural heritage. Today, she will present India's approach to the protection of traditional knowledge, including mechanisms such as the Traditional Knowledge Digital Library, as well as the interaction between patent law, biodiversity regulation, and geographical indication. She will also touch upon emerging challenges, including the impact of digital access and artificial intelligence on traditional knowledge systems. Vidisha, the floor is yours.
Thank you, Fabrizio. I'll first share my slide. Good morning, good afternoon, and good evening to everyone. And thank you for joining this webinar. Thank you, Fabrizio, for generous introduction. So today I will be speaking on the intersection of intellectual property, traditional knowledge, traditional cultural expression, and cultural heritage. And I'll be focusing on Indian legal and policy framework. So let me first begin with a story that many of us are already familiar with, but whose implications are still unfolding. In 1990s, patents were granted outside India on turmeric for wound healing and neem plant for pesticidal use. For centuries in India, turmeric has been used for wound healing. It is a part of our everyday life, applied to cuts, used in home remedies, and described in classical texts of Ayurveda. So the patent was granted by the USPTO to researchers from University of Mississippi Medical Center for the use of turmeric in wound healing. So the claim was basically directed to a novel therapeutic use of turmeric. Similarly, neem tree has been used in India for centuries for medical purposes, agriculture, and pest control. Farmers in India traditionally use neem extracts as a natural pesticide, and a patent was granted by European Patent Office to W.R. Grace and Company and United States Department of Agriculture for the neem-based fungicidal composition. So these two development badly irritated the Indian stakeholders, and they did not took this in good taste. And with the intervention of Indian government and research institutes, these patents were revoked. But the deeper lesson which Indians learned from this was not that the patent was obtained, but it exposed a systematic issue. Traditional knowledge existed, but since it was not documented in the formats of the patent offices, it was actually invisible for the patent systems. So turmeric and neem cases became a turning point for India, and it led to India's decision to digitize its traditional knowledge and to ensure that such knowledge could be recognized as a prior art as per the patent systems. In essence, these cases taught us that the problem was not the absence of traditional knowledge, but it was the absence of recognition. So traditional knowledge existed, but there was no recognition of this knowledge as per the patent systems. India is one of the world's largest, richest traditional knowledge ecosystem. We have more than 5,000 years of documented traditional knowledge. Medical system, we have medical systems such as Ayurveda, Yoga, Siddha, Unani, which are our traditional knowledge. Over 7,000 medicinal plant species have been used traditionally. More than 22 official languages have been recognized, and more than 1,000 dialects have been recognized as our cultural heritage. Thousands of traditional craft, textile, and cultural expression exist in India, and there is a deep linkage between traditional biodiversity, culture, and community knowledge. Therefore, traditional knowledge in India is not historic, it is living and evolving. And that brings us to why this issue is far more important today. So today we are no longer dealing with the isolated cases of biopiracy. We are actually witnessing a systematic interaction between innovation system and the traditional knowledge system. Of late, three global developments are driving this shift. The first is rapid digitization of cultural heritage. Secondly, increasing commercial use of traditional knowledge. And third, global innovation drawing heavily from biodiversity. So this has created a fundamental tension between the modern IP system and community-based knowledge system. And India sits at the center of this discussion. So to understand it better, I have this slide where we must first understand what we mean by traditional knowledge and what creates a problem. So the problem is not the absence of law. There are laws, but the problem is the mismatch of the legal design. Traditional knowledge, as we all know, is often undocumented, collectively owned, culturally sensitive, and is used across borders. So it has issues with respect to ownership, commercialization, and cross-border use. So the issues are created by these three things basically. And this mismatch becomes clearer when we compare traditional knowledge with the classical IP system. So the modern IP system are built on the concepts of novelty, individual ownership, and limited term of protection. Traditional knowledge, on the other hand, is collective. It's ancient. continuously evolving and often orally transmitted. So there is not merely a legal gap. So this is basically a legal gap, and it reflects structural incompatibility between two fundamentally different knowledge systems, which is why traditional IP tools alone are not sufficient for this protection. So this incompatibility first became visible through a series of important cases. Two I have already discussed, the turmeric and the neem case, and another one was the basmati rice case. So turmeric, neem, and basmati rice biopiracy cases marked a turning point for India. These cases showed that traditional knowledge must be documented and recognized as a prior art. And importantly, they shifted traditional knowledge from a cultural concern to a global IP governance issue. So India responded to this challenge in a very unique way. The method was defensive protection model. So India developed the traditional knowledge digital library, which we commonly called as TKDL. So it was developed in 2001. TKDL is not merely the documentation of our traditional knowledge, it is a strategic intervention within the patent system. It converts the ancient knowledge into a searchable prior art. So, till the development of this TKDL, prior traditional knowledge was not searchable and it was in very different languages. So, by uh, making this traditional knowledge digital library, everything, all the traditional knowledge of India has, which was written, basically Ayurveda, Siddha, Unani, and Yoga traditional knowledge have been documented and digitized, and they have been translated into English and Hindi languages. TKDL contains over 400,000 formulations, and it is available in multiple languages. It is used by major patent offices such as USPTO, EPO, UK, IPO, JPO, etc. And thousands of patent applications have been rejected or withdrawn based on the search results obtained through this library. So TKDL, or this defensive mechanism, is not only the India's approach. India's approach goes beyond this defensive mechanism. So India framework is constitutionally grounded in our constitution of India, and our constitution of India under in articles 29, 49, 51 AF and 48 48A collectively supports protection of cultural heritage and biodiversity. So this constitutional foundation is also reflected in our statutory laws as well. So, the Indian Patents Act has a provision under Section 3P, which prohibits the grant of patent to inventions relating to traditional knowledge. So, under Section 3P, uh, all the inventions which relate to traditional knowledge are exempted from patentability. So, it represents one of the clearest statutory recognition of traditional knowledge globally. India also addresses this issue of protection of traditional knowledge directly through another law, which we call as biodiversity law. The Biodiversity Act regulates access to biological resources. It introduces prior approval and benefit sharing mechanisms. And this reflects a shift from IP protection to resource governance. So under Biodiversity Act, a person who wishes to obtain IP rights for IP rights needs to obtain a prior approval process. And if they wish to commercialize any biological resource obtained from India, then they also require to share benefit with the respective communities. So biodiversity law is a very strong law as per the Indian system, which it reflects a shift from IP protection to resource governance. So let me illustrate this with an example of Kani tribe. So this Kani tribe story is one of the most important real world example of how traditional knowledge can be ethically used. In the forest of Kerala, the Kani tribal community had long used a plant called Arogya Patch. They have used it to combat fatigue during their long walks in the forest, and it was part of their lived knowledge passed on through generations. Scientists from Tropical Botanical Garden and Research Institute studied about this plant, and they came up with a formulation, a herbal formulation for fatigue. So now what is important here and the purpose of telling this story is not just that a drug was developed from the traditional knowledge of Kani tribe, but what happened next. So what happened next is important here to understand. Instead of commercializing the product in the conventional way, a benefit sharing arrangement was created. A portion of the license fee and the royalty which was generated from the commercialization of this drug was allocated to the Kani community. Operationalize this, a trust was created, which is often referred to as Kani Trust, and it was established to ensure that the benefits were distributed within the community. These funds were used for the community development, supporting healthcare, education, and improving basic living conditions of the tribe. So, for the first time, traditional knowledge was just not acknowledged, it was economically valued and returned to the community that created it. This case became one of the most important and the earliest global example of what we now call as access and benefit sharing, and later which has also reflected in international frameworks such as Nagoya Protocol. So this example demonstrates a crucial shift from extraction of traditional knowledge to partnership with the communities and to equitable sharing of benefit. So the lesson which we learn from this story is very clear. The question is not whether the traditional knowledge should be used. The question is whether it is used with fairness, recognition, and shared value creation. So if the turmeric and neem story, which I discussed earlier, they represent what goes wrong. The Kani story represent what responsible innovation looks like. So another important tool in India's framework is geographical indication protection. So GI protection represents the most successful model of community-based IP protection in India by linking the product with the cultural heritage. It also helps in transforming the cultural identity into community-owned IP. However, not all cultural expressions fit into GI, so we have another legislation, which is the Copyrights Act. So copyright protects expression, but it does not always help in protection of the collective ownership of culture. Therefore, it remains only as a partial solution to the protection. So, why? Which is why India adopts a broader legal approach. So, apart from the previous the patent, biodiversity, GI, and copyright, we also have protection under trademarks law, design law, and cultural heritage law. So this domestic framework of India is also aligned with the global systems. The Indian laws are well aligned with Convention on Biodiversity, Nagoya Protocol, TRIPS Agreement, UNESCO, and WIPO discussions which are going on right now. India was also very much involved in the treaty which came up in 2024, the GRTK treaty. But the next challenge is already emerging now. So the new challenge which we are now going to face is the AI. So the next challenge is not biopiracy, it is the digital extraction. AI systems are now learning from traditional knowledge at scale. And this raises a fundamental question about ownership and benefit sharing of the traditional knowledge. So India has been actively shaping global discussions on this. And India has influenced the shift from misappropriation to documentation to governance. And India is involved with WIPO in lots of discussion. So what does India's model tell us? India has a model in 5 pillars, and the India's model rests on these 5 pillars, which are basically the defensive protection, which is through TKDL, patent protection by exclusion of traditional knowledge, biodiversity, which provides a mechanism of benefit sharing, GI protection, and cultural preservation. So India has adopted a multi-layered legal system, and this has implication on us as practitioners. So as patent professionals, for us, we now do not have a choice to have expertise in traditional knowledge. Or it is now the necessity of the hour, and we need to understand what is traditional knowledge, how important it is, and how to protect it from uh, getting from the misappropriation, basically. So let me close by returning to where we had begun. When neem and turmeric patents were revoked, it was not merely a legal correction. It was a signal to the global IP system, which had begun to recognize the traditional knowledge it had long overlooked. But today, the challenge is far more complex. The challenge is basically the new technologies which are coming, basically the AI, biotechnology, and other digital platforms. And this brings me to my final thought. Traditional knowledge is not simply a resource, it is a civilizational inheritance. The challenge for IP law is not only to reward innovation, but to respect inheritance. So thank you. We'll have question answer later. Fabrizio, up to you.
Yes, thank you very much, Vidisha, for that very insightful presentation and for sharing India's comprehensive and structured approach to the protection of traditional knowledge. So our next speaker is now Alejandro Rangel Ban from Baja and Ringen Correa in Mexico. Alejandro will provide us with an overview of Mexico's legal framework for the protection of cultural heritage, including the role of copyright, appellation of origin, and the specific legislation adopted to safeguard the cultural heritage of indigenous and Afro-Mexican people and communities. He will also share practical examples of misappropriations and policy responses. So, Alejandro, the floor is yours.
Thank you. Thank you very much, Fabrizio. So I would like to start by giving some background and some context of where we stand right now in Mexico and its cultural heritage, its cultural traditions. As you can see in the screen, this is a map of Mexico. Mexico is a pretty large country with 32 states, with different cultural expressions, with different cultural activities, different peoples. Before the Spanish conquest of the country, of what today is Mexico, there were several communities, several civilizations that inhabited what today is called Mexico. Right now, Mexico has more than 130 million people population. From those 130 million, almost 17 million are indigenous peoples, with over 364 linguistical variations, which are divided into 68 groups. So we can say that there's a very rich country culturally speaking. We have more than 54 indigenous groups, recognized indigenous groups in Mexico, each group with different language, with different cultural expressions, with different gastronomy, with different cultures at the end of the day. These groups are divided or expanded throughout the country, depending on the population, depending on the weather, depending on the whole characteristics of the country or of the specific place they are in. Their cultural expressions will change. Some examples of these traditional peoples are the Cucapá, the Tarahumara, which have their own cultural expressions, such as the dressings, the different languages, Huichol, which some of you may know, Totonaca, just to name a few, Trique, Tzotzil, and of course in the Maya Peninsula. Each town has a very different expression and very different approach to culture. So what was the legal framework before and after recent amendments to the IP system in Mexico? First of all, we have the federal copyright law. The federal copyright law before 2022 included only one requirement to use the cultural expressions. The cultural expressions were understood as part and ownership of the whole country, of the state at the end of the day. The only requirement that the federal copyright law included was that you have to quote, you have to cite what community does the cultural expression come from. Besides that, there was no additional requirement to exploit any cultural expression which was included in the country. Now, recent amendments to the federal copyright law require written and express authorization from the specific community to use and exploit a certain cultural expression. Additionally, we have to identify the holder community from which the cultural expression comes from. And the Copyright Office will also work as the authority to solve any dispute resolutions that may arise on cultural expressions. But it was understood that the federal copyright law was not enough to cover the whole spectrum of cultural expressions in Mexico. So additional legislation was included to try to apply to all the traditional cultural expressions. The federal law for the protection of industrial property includes both appellations of origin and geographical indications. Mexico owns more than 18 appellations of origin, recognized appellations of origin, and also more than 15 geographical indications. Some of you may know some of the appellations of origin, which are world famous, such as tequila, mezcal, chile habanero, or many other artistic expressions that are protected by appellations of origin or geographical indications. Additionally, the industrial property law includes the protection for collective trademarks, which could include several groups of collective and traditional expressions, as well as certification trademarks or trademarks for certification that allow certain collectives, certain peoples to protect their whole trademarks. Additionally, the federal law for the protection of industrial property includes specific prohibitions for a person that is outside of a specific community to register a trademark that reproduces traditional cultural expressions belonging to a certain community. So now we've seen the federal copyright law, we've seen the federal law for the protection of industrial property. This legal framework was not deemed as sufficient to properly protect, to properly recognize the traditional cultural expressions of all the collectives, the indigenous peoples in Mexico. So, in 2022, a new law was enacted. It is quite a long name, sorry. It's the federal law for the protection of the cultural heritage of the indigenous and Afro-Mexican peoples and communities. So now Mexico has a specific law to recognize traditional cultural expressions for the specific indigenous and Afro-Mexican communities. As you can see from the title, this is one of the first statutes that recognizes Afro-Mexican peoples, not only indigenous peoples that were in Mexico before the Spanish conquest, but also Afro-Mexican peoples who have their own traditional expressions, traditional knowledge. This was back in 2022. So what does this federal law include or provide? Its main objective is to recognize and guarantee the protection, safeguarding, and development of the cultural heritage and collective intellectual property of indigenous and Afro-Mexican peoples and communities. From this description, we can identify that besides having the objective of protecting and developing the cultural expressions, the cultural heritage, it states that the intellectual property of indigenous peoples and Afro-Mexican peoples is a collective intellectual property. Instead of being a private right, as in most of intellectual property and industrial property rights, this new law recognizes these rights as collective rights. Not one person in the community is the sole owner of the cultural expressions, but the community as a whole is the collective owner of these rights, which is something new in the Mexican industrial property system. This new law also states that these rights, the elements of the cultural heritage, the cultural expressions of each people, of each collective, are inalienable, imprescriptible, unrelinquishable, unseizable right of collective nature. This means that besides being of collective nature, they are not owned by a single person or a single entity. These rights will not go into public domain. These rights are passed through generations. They are part of the community, an integral part of each community. These cultural expressions will not ever go into public domain. So what are the main characteristics of this specialized law for traditional knowledge and cultural expressions? As I said, this is a collective industrial property right. Instead of what we have private rights for trademarks, private rights for patents, or any other figure that we have seen for industrial property, this law recognizes only collective rights. There is no time limit for these rights. These rights were passed through generations and will not go into public domain. What the law attempts is to prevent misappropriation from third parties that are not part of a certain community. Only the community can authorize or deny or reject use of a specific cultural expression. Some comparison with other specific laws, for example, trademark and patent law, to enforce these rights, these collective rights, the specific people do not have to ensure a bond to have an injunction or precatory measures for the misappropriation of their rights. This law is in clear benefit of the collective peoples. The misappropriation and unauthorized use of certain traditional cultural expressions can be sanctioned not only through fines, through administrative infringement, but also the unauthorized use of cultural expressions without the authorization of the specific community may be a felony under criminal code. It is absolutely necessary to have express authorization from the specific community to use or to reproduce a traditional cultural expression. If the whole community does not agree in granting an authorization for the use of a traditional cultural expression, then such use will not be authorized. The law states that a certain registry must be, or that a registry must be implemented to recognize and to identify the traditional cultural expressions of each community. However, this registry has not come into effect as of yet. The law also states that the Copyright Office will be in charge of ruling on potential infringements and potential unauthorized use of cultural expressions. Now, here we have some examples that came about before this most recent law. And one of the reasons this law was enacted was because at the time, before it was enacted, there was no legal framework to properly cover, protect the traditional cultural expressions. So we have the misappropriation by foreign people outside of Mexico, people outside of the specific communities which are owners of the traditional cultural expressions that reproduced without authorization certain elements of certain traditional cultural expressions of Mexican communities. In this specific case, we have a quite famous case of the French designer, fashion designer Isabel Marat, who reproduced certain elements of the Purépecha community in Michoacán without obtaining the specific authorization. Additional cases, such as Zara and Anthropology, which are well-known stores or fashion stores around the world, which reproduced without authorization certain elements, certain traditional cultural expressions of the Mixtec and culture from Oaxaca. As you can see from this example, certain elements are being reproduced without authorization. Another famous case was Carolina Herrera, also a fashion designer, who reproduced the Tenango de Doria elements, a community, Otomi community in Mexico, without requesting authorization or obtaining the proper authorization from the community. Another example of this cup of coffee for chocolate made by Nespresso or Nescafé, which also reproduces these elements without authorization. So we have a lot of cases that happened before the entrance into effect of the latest legislation, which made it quite necessary to have a specific and specialized legislation for traditional cultural expressions. More examples of this. Another example is Cerveza Indio, manufactured by Heineken, who introduced these Voladores de Papantla, which is a cultural celebration for a specific Mexican community, without obtaining the express authorization. Back when this case happened, the specific law was not enacted, so negotiations have to be made by the specific community and the brewery, which ended up into an agreement. More examples. So what do we have now? This is an additional example of how we can do things. At the end of the day, what the law provides is the possibility to properly protect traditional cultural expressions. But at the end of the day, what the law intends is that the traditional community can also benefit from the traditional cultural expressions, even though they have the right to reject a potential offer by a company to use the traditional expressions. They can also agree and mutually benefit through license agreements between the community and maybe a company that would like to use such traditional expressions. On this example, on this slide, you have the latest shirt, latest kit, latest jersey for the Mexican team for the upcoming World Cup. This jersey represents the Aztec calendar. Adidas obtained through legal means an authorization by the National Institute of Anthropology and History in Mexico to reproduce this calendar, to have a license to use it. And this is an example of how things can eventually work out without the need of imposing any sanction, but a community, even the state, can benefit through license agreements. On the other hand, we have another example of certain potential misappropriation of a community, of the traditional cultural expressions of a community in Oaxaca, which may show the use of traditional cultural expressions without authorization and the reproduction of certain aspects and elements of traditional cultural expressions. So let me just give some final thoughts. According to the Mexican framework, traditional cultural expressions are not part of the public domain and cannot be used freely. Express authorization by the community holder or the holder community must be obtained to properly use and reproduce traditional cultural expressions pertaining to a specific community. Traditional cultural expressions are not individual property, but are collective property, which may be quite important change in the legal framework. The copyright law, the federal law for the protection of industrial property, and this latest law for traditional cultural expressions are the most important laws in the legal framework to not only recognize, but also to protect traditional cultural expressions. Finally, as I said before, what the law provides is not only to prohibit or to reject any use of the traditional cultural expressions, but to encourage people to obtain the necessary authorizations through the specific communities to have an authorized use of traditional cultural expressions, and this way having a mutual benefit for both the community and the potential licensee. Thank you very much.
Well, thank you very much, Alejandro, for that excellent presentation and for illustrating how different legal tools are being used in Mexico to protect cultural heritage. Now, our third speaker is Modica Boța-Moisin. Modica is the founder of the Cultural Intellectual Property Rights Initiative and an expert in the intersection between intellectual property and cultural heritage. She has also participated in the negotiation of the Intergovernmental Committee of the World Intellectual Property Organization, representing local communities. Today, she will share her perspective on the limitation of the current intellectual property system and protecting traditional knowledge and traditional cultural expression, as well as the development of a right-based approach in Romania. Modica, the floor is yours.
Thank you very much, Fabrizio. So, can you see well my screen because the Zoom just disappeared? Can I get a confirmation that the presentation is working well as the Zoom disappeared and I don't see anything?
We don't see it, Modica. No.
One more time. With due apologies. It worked all well in the rehearsals. and obviously the moment of... So thank you very much for this invitation. I am speaking to you now from the land of my ancestors. I am in Țara Beiușului, in the home that my great-grandparents built. And Țara Beiușului, I will show you in a moment, is in the west of Romania, closely bordering Hungary. So Romania, for those that are not familiar with our country, is a very diverse country. It has many similarities in that sense with India and Mexico, as we have numerous local communities with very particular knowledge systems and traditional cultural expressions. As you can see from just this brief slide with images, the identities are so different, and this is just a few pictures, so we have a lot more communities. As you see, my community has a very different identity than we have captured in these pictures. In current day Romania, we can ethnographically identify what in our language is called countries, so Țara Beiușului would be the land of Beiuș, then we have a number of different countries. What this means is that these are territories that have a very specific cultural identity. They have particular traditions, they have a particular dialect. So we are all Romanian nationality. We speak Romanian as the national language. Romania is a unitary state, but our cultural identities and the knowledge systems that we care for and we transmit generationally are very, very unique, and they differ from one country to the other, so to say, from region to region, and sometimes these can be very closely positioned geographically. I am speaking to you today as a member of my local community, as a lawyer that is representing my local community in the international negotiations at WIPO, and also in developing what we would call a bottom-up approach to protecting traditional knowledge and traditional cultural expressions in Romania. There are a few particularities in our cultural context that differentiate us maybe from other European countries. So in that sense, the way traditional knowledge and traditional cultural expressions is perceived and protected around the EU is not the same, or is not a homogeneous perspective. To us, it's very important to differentiate between traditional cultural expressions, craft products, and artisanal products. In our language, we have a particular word that means craft, and that is different than the word that means artisanal. It's not the same in all the languages, and it's not only that the word is different, but what the respective product embodies and contains is also very different. So traditional cultural expressions, as the colleagues before me, the speakers before me have already mentioned, are those expressions that embody traditional knowledge. Traditional knowledge is generationally held, cared for, and transmitted within a community that is connected to a particular territory, and it's very tied to not only the cultural identity, but the spiritual identity of the community, and it has multiple functions in the community. So it's emblematic, it's distinctive, and it's almost, to us, we see it as a human right, not only an economic right, as intellectual property rights are. Craft products, some of the craft products can be traditional cultural expressions, while other craft products are not. So craft products are defined by the fact that they are made with a traditional technique, but not all these products are intimately linked to identity or have a spiritual and ritual role in the community. And lastly, in the big, let's say, bubble of what we call handmade, that's where we place artisanal products. And in the context of our country, artisanal products were a concept that was developed during communist times. So it wasn't there prior to this era and regime. And artisanal products are inspired by the traditional aesthetic, but they are made in series. So they are made in large quantities, and they are not fully made by hand. Sometimes machines can be used, and they are not identitary in that sense. They don't embody necessarily the traditional knowledge. Some of them are simply artistic works, and it's a very non-homogeneous treatment of these products, because some of them are of very low quality, others can be of very high quality. So handcrafted and handmade are not the same in terms of concepts, and this leads to difficulties when it comes to legal protection. I'm sharing, as well as my colleagues, a few examples of misappropriation of Romanian traditional cultural expressions. And I will start, of course, with the one that is the most connected, right, to my identity. And this is cojocul bincenesc that we see in this image that has been appropriated by a large luxury fashion company based in Europe, in France, without the consent, without the free prior informed consent, acknowledgement, or compensation of the source community. And this has catalyzed a process of our communities seeking to develop sui generis protection, full and effective protection of our traditional cultural expressions. As you can see, this traditional cultural expression is very alive in our territory. In Țara Beiușului, we have craft custodians that are continuing the craft, and we have also programs that run educational programs in schools for children and youth, so that this knowledge is shared, from a very young age, that the traditional knowledge is indeed generationally shared, and that this notion of understanding what it means is embedded from a very early age into the consciousness of our youth. Another example is what we call cămașa cu ciocanele, like the blouse with hammers. It's from another region of Romania. It has been a very desired a traditional cultural expression featured in many collections. And again, it's a very living traditional cultural expressions, and the custodians of this traditional cultural expression are also developing their bottom-up approach to protect this traditional cultural expression. So an idea that is very important when we look at how to protect traditional knowledge and traditional cultural expressions, and how this is interfacing with the conventional IP system, is to understand the unique nature of TK and TCEs, and the fact that indigenous peoples and local communities have inherent rights to protect TK and TCEs, and these rights are pre-existing the conventional IP system. And I think the example Alejandro Gray gave in the Mexican sui generis law that recognizes the inalienability, imprescriptibility, and the fact that these rights cannot fall in the public domain is a clear example of how TK and TCEs are destined to be protected. I will just take once again just this important nature, the cumulative criteria that we always have in mind when we think about what is the subject matter when we talk about TK and TCEs. This is knowledge and expressions that are created, generated, received by, or revealed to. And in this sense, we have to understand that there are very different forms of receiving the knowledge, and that indigenous peoples and local communities have very different relationship with knowledge than conventional IP holders, for example. So it's a very different relationship with that knowledge. There are sometimes in our communities, we have duties and obligations towards these expressions and this type of knowledge that are embedded in our customary laws and traditions, which we must respect. And oftentimes the conventional IP system is incompatible with our way of engaging with this knowledge. They are linked and are an integral part of the cultural and social identity and traditional heritage of indigenous peoples, as well as local communities, and they are transmitted generationally, whether consecutively or not. So this is also the wording that you will find in the working documents of the WIPO IGC, the current draft documents for the that are discussed and negotiated for the international protection of TK and TCEs. There were many examples in the prior presentations of how the IP system fails TK and TCEs protection, and I will just want to give you an example from our cultural context. where there have been attempts also to register a distinctive element from the Beiuș Cojocu Binșeinesc, the Beiuș sheepskin vest. So we often have this conflict between the individual exclusive rights and the collective rights that the community is entitled to, which are at the moment not specifically recognized in our legal system. So here is where we have to take active measures of following all trademarks applications and objecting, filing oppositions when such cases occur. And this is a very big burden on indigenous peoples and local communities in general. It's also very important to understand that the type of harm that the inadequate protection of the inherent pre-existing rights of indigenous peoples as well as local communities and the erroneous grant of intellectual property rights over TK and TCEs, the type of harms that this causes are systemic. So they are not just economic harms that can be redressed through benefit sharing and compensation, but they are also cultural and spiritual harms that are sometimes irreversible. This is very important to understand when approaching cases that involve conflicts between the conventional and the unprotected in some cases. It's also very important to have in mind that there's a very big difference between safeguarding measures under the UNESCO conventions and the full and effective IP protection under that we are seeking under either or within the IP system, and how the IP system needs to change, to reform in order to offer full and effective protection to TK and TCEs. In Romania, TK and TCEs were only recently introduced in the national IP strategy in the terms of recognizing this specific terminology. So it was only in December 2023 that the new national IP strategy was adopted, and now these concepts are embedded in the strategy. And in light of our Article 33 of the Romanian Constitution, the state has a positive obligation to protect and preserve what we call cultural inheritance. So the concept of cultural inheritance is different from the institutional concept of tangible and intangible cultural heritage, and comes back to link with the rights of the local communities, these collective rights of local communities to protect and benefit from their TK and TCEs. So there's a long way ahead for us here, but a pilot project was conducted over the past 14 months in Țara Beiușului. We developed this project with the support of the World Intellectual Property Organization at the request of our National Copyright Office and the Office of Inventions and Trademarks. We have two IP offices or two branches, two offices that work on IP matters. One is under the Ministry of Culture, one under the Ministry of Economy. The strategy was, we developed a strategy that includes a collective mark, includes a best practice of how to engage with the local community in Țara Beiușului based on free prior informed consent, credit, and compensation. And we have mapped some of the most important traditional cultural expressions and associated TK so that we can develop a sui generis database protection in the future. But this is, as I said, a bottom-up approach. So we are seeking to hopefully have a unique type of protection in Romania as well. At the European level, there has been a recent development, which is the new GI regulation for craft and industrial products. But as you've seen already in some of the presentations, and I briefly mentioned as well, it is not fully protected, offering protection to our local communities. To sum up the discussions at the WIPO IGC, some of the most challenging perspectives or topics that come into play is the understanding, the comprehension that TK and TCEs are indivisible and inseparable. So in this traditional cultural expression that I'm wearing, Cojoco Binchenescu have, generational traditional knowledge, we have cultural significance, we have symbolism, spiritual meanings. We cannot really divide the two. So this artificial separation that the conventional IP system is forcing us to do is very difficult to accommodate for indigenous peoples and local communities. Also, it's important that the protection system that will be developed at an international level covers both positive protection and defensive protection. And as colleagues have already mentioned, the notion of public domain is very problematic in the sense that for indigenous peoples and local communities, the pre-existing rights that we have in respect to our TK and TCEs are definitely putting us in a position to not agree with the fact that they were ever in the public domain. I lastly want to recommend a fantastic book by Wen Wendland, who was the previous director of the TK division at WIPO. And those of you that have followed the negotiations of the DR-TK treaty, I'm sure you know and probably know the book. But it offers a great insight into how this international multilateral process is developing and the difficulties it takes, the dialogues we need, and the mutual understanding and empathy we need to reach a model that is balanced and offers full and effective protection for TK and TCEs. Thank you.
Well, thank you very much, Monica, for that very thought-provoking presentation. We have now heard three very valuable perspectives from different regions of the world: India, Mexico, and Romania, each offering distinct legal and policy approaches to the protection of traditional knowledge and cultural heritage. So, if time permits, I would like now to ask a few questions to our panelists before opening the floor to the audience. So, I have a question for each of you. The first question goes to Vidisha. So, Vidisha, India has developed the traditional knowledge digital library as a form of defensive protection against misappropriation. How effective has this tool been in preventing the grant of patents based on traditional knowledge?
Thank you, Fabrizio. As I had mentioned earlier, TKDL has been highly effective as a defensive tool. But its effectiveness must be understood in a very specific way. So firstly, at operational level, it has directly prevented the grant of patents to inventions relating to traditional knowledge. This library is used by major IP offices, as I had already mentioned, and this has led to thousands of rejections, withdrawals, or amendments of patent application that related to traditional knowledge and attempted to claim traditional knowledge. Secondly, it has created traditional knowledge as a searchable prior art. So this traditional knowledge digital library is structured and it provides a classified prior art search, which is aligned with International Patent Classification System. And thirdly, it acts as a deterrent for the applicants who wish to patent the traditional knowledge. However, at the same time, there are few limitations of this TKDL also. Basically, the first one is that it is purely defensive mechanism, and it although prevents misappropriation, but it does not provide any positive right to the community or the owner of the traditional knowledge. Secondly, this covers and protects the documented traditional knowledge of India, but India also has a lot of undocumented and orally transmitted traditional knowledge which is not protected. So that still remains vulnerable. So traditional knowledge has been effective in preventing wrongful patents, but it is not a complete solution for protection and monetization of traditional knowledge, which we now feel. So we now are looking for a much better protection now. Thank you.
Thank you very much, Vidisha. Now we have a question for Alejandro. So Alejandro, Mexico has adopted a specific law to protect the cultural heritage of indigenous and Afro-Mexican peoples and communities. What do you consider the most innovative element of this legislation compared with traditional intellectual property frameworks?
Well, I think that the most innovative parts of this new legislation are particularly the collective aspect of the IP rights. This collectiveness of the rights, which had not been previously recognized by other specific statutes, is quite innovative in Mexico, specifically when it comes to intellectual property rights. Additionally, I think that the term of public domain, as Monica mentioned, maybe the consideration that maybe these traditional cultural expressions were never in the public domain or should have never been in the public domain. This raises some issues that could be eventually legislated, but the fact that people in Mexico were used to use freely these traditional cultural expressions, and now they're being restricted and must obtain authorization, which may cause some issues from the part of the free use of traditional cultural expressions, which were owned by everyone in the country, to the fact that the non-authorized use of these TCEs may even constitute a felony. So I think that those two are the most important aspects and most innovative aspect of this legislation.
Thank you very much, Alejandro. And finally, I have a question for Monica. So, Monica, based on your experience participating in negotiation at the WIPO Intergovernmental Committee, what are the main obstacles to reaching an international agreement on the protection of traditional knowledge and traditional cultural expressions?
Thank you for the question. As I mentioned when I was concluded, I think one of the main obstacles is first to have that change of mindset and to understand the indivisibility of TK and TCEs. So these things cannot be separated. When we think about developing a system for protection, we have to look at TK and TCEs as a one interconnected body. And that is very difficult to do in jurisdictions that don't have maybe such strong bottom-up approaches and communities that are really explaining the what TK and TCEs means to them. So in societies where conventional IP has been driving what you call innovation, and where there has been this conception that everything that was there before is up for use and exploitation, is very difficult now to put restrictions, no? And many people are defensive in that sense, so they don't want to give up what was so free before. It's very difficult to regulate or to say no after it has been so openly used, and there's many historical arguments there. So the indivisibility is very important, because that or imposing a separate distinction between regulating TK in a certain way and TCEs in a certain way, and having two different instruments, this would basically contravene with our belief systems and those of and the world's views of indigenous peoples and local communities. Secondly, it's very challenging really to understand what is this balance between the different IP tools, conventional IP tools, and this new way that will be there to protect TK and TCEs. And there are obviously a lot of different interests that are conflicting, and that's where it really breaks the world into two, really. So there's a lot of dialogue to have, and a lot of as I said, empathy, and a lot of examples that we really need to look at this and to think about the value of traditional knowledge and traditional cultural expressions, and how the custodians of this knowledge and cultural expressions should be at the forefront, and to be the beneficiaries of this protection mechanism.
Well, thank you very much, Monica. Now we're going to switch to the attendees' questions. So I have a question from Victor to Vidisha. In the case of TCEs shared by Vidisha, was the product based on the TK patented? If so, we'll be interested to know whether the TK was cited during patent prosecution.
Thank you, Victor. Actually, the cases which I had cited, the turmeric, neem, and the basmati case, at that time we did not have TKDL. However, now patent offices are regularly, when they are examining the patent applications, they go through the TKDL, they search through the database, and they cite. They in the examination report, they cite the documents from the TKDL library, and there is often an objection under section 3P that the invention relates to the traditional knowledge. Also, there is an objection under lack of novelty, that the invention relates to already is anticipated in view of the traditional knowledge existing in India. So this library has been extensively used by Indian Patent Office and also by other offices, and which has helped in identifying the prior art.
Thank you very much, Vidisha. Now we have a question from Ana Claudia to Alejandro. There are any database having information on TK and or TCE like in India?
No, the answer is no, not yet. There's no Korean registry for traditional cultural expressions or traditional knowledge, as it would be for trademarks or patents. What the plan is that for there to be a specific registry, or let's call it catalog, of traditional cultural expressions for a particular company or particular person who can search to see if the traditional cultural expression is protected or is owned by a specific community. And once we can identify the ownership of a TC, then we can contact the specific community and approach them to see if they would be willing to license or authorize the use of the cultural expression. However, at this point, there is no catalog, there is no registry, but I understand that there are plans. What is difficult is that there are so many communities and so many traditional cultural expressions that may not be only used by a certain community. For example, there is not one Mayan community, but there are several communities that may share a specific traditional expression, which may be owned by both or by many. So it is not easy to identify and specify the ownership of the TCs, but I know that there is a plan to enforce a registry or a catalog.
Okay, perfect. Yes, please, Monica, you have an answer for Steve's questions. Steve mentioned if there are any more databases like the TKDL for other countries. Please go ahead, Monica.
So in 2021, there was a database that we, as the Cultural Intellectual Property Rights Initiative, together with our partners in Laos, the Lao Republic, the Democratic Republic of Laos, we developed supporting the Oma people in northern Laos in a cultural misappropriation case against or an alleged cultural misappropriation case against a Europe-based company. We developed a legal strategy that included the creation of a traditional cultural expressions database.
And Vidisha, really the TK database in India was my source of inspiration at that time. So because we knew there wasn't anything on TCEs, and how can we react in a constructive way? Because it's very important to understand communities do not have the financial resources to develop to have lawyers working for this. So we developed a traditional cultural expressions database that is now fully controlled by the Oma people. And it acts in a way as a prior art, if you want. So at this time, we tried to be proactive in ensuring that cultural misappropriation of their TCEs can no longer occur. And the database is based on the framework of the 3Cs rule, the free, prior, informed consent, credit, and compensation. It invites collaboration, but in a specific framework, so that it doesn't exclude the OMA from being involved, and that all the access and uses of their TCEs are with their free, prior, and informed consent. So this would be an example I left, or I can share in the chat for Stephen Van Dyke the link to this project.
Thank you very much, Monica. Now we're going to answer last questions. So a question about biological resources. It's a tough one, I think. It said, when do you need MBA approval for testing a biological resource? Is that when you want to test or analyze it, or when you want to patent a property found in it? So who wants to answer this question?
I can answer from Indian perspective. So, the National Biodiversity Act requires approval for in case you are interested in obtaining any IP for use of the biological resource, then approval is required. Also for testing and any kind of commercial use, approvals are required under different sections. So any use of biological material of Indian origin, always approval under different sections and under provisions. Approval is definitely required for testing, commercialization, and for obtaining IP rights.
Thank you, Vidisha. So unfortunately, we run out of time. We have excellent questions from Takeshi, Israel, and other participant, William. So we will maybe answer this through an email. We're going to send this to the to each of you. So now we are going to finalize this panel. So thank you very much to all speakers for their excellent presentation and thoughtful insights. Today's discussion has clearly shown that the protection of traditional knowledge and traditional cultural expression remains one of the most complex and evolving areas at the intersection of intellectual property, cultural heritage, and community rights. We have also seen how different jurisdictions are developing innovative legal and policy approach, while international discussions continue to evolve. I would also like to thank the International Association for the Protection of Intellectual Property, APPI, for organizing this webinar, and all of you for joining us today. It has been a pleasure moderating this discussion. Thank you very much, and I hope to see you again at future APPI events. Thank you.